Welcome to the Deep Dive. We explore the complex rules that shape our world. Today, we're asking something fundamental, really. We know nations have natural resources, but how exactly does the state manage them? Who calls the shots?
That's exactly it. And the framework for that, at least concerning what's underground in South Africa, is the Mineral and Petroleum Resources Development Act, the MPRDA, Act 28 of 2002.
Right, the MPRDA, and it's not just some dusty old law, is it? It was assented to back in October 2002, started running in May 2004, but it's constantly being updated. Our sources show the last changes were incorporated as recently as October 29, 2024.
It has to be dynamic. It's dealing with massive industries and fundamental questions of ownership and development.
So our goal here is to cut through that complexity. Whether you're just curious about how this works, or maybe you're a law student trying to get your head around it, we want this deep dive to give you a clear understanding.
And to do that, we need to start with the philosophy behind it all. The Act's preamble acknowledges upfront that minerals and petroleum are finite. They're non-renewable. That's the physical reality.
But the legal reality, the big shift, comes in Section 3, doesn't it?
Absolutely. Section 3 is revolutionary. It states clearly these resources belong to the nation, full stop. And the state acts as the custodian of these resources for the benefit of all South Africans. That really turned the old system on its head where, owning the land often meant owning the minerals beneath it.
Completely. This establishes national sovereignty over the resources. And this custodian role, it leads directly to the Act's main goals, which you find in Section 2. There's sort of a dual mandate here.
Okay, what are the two sides of that coin?
On one hand, it's about sustainable development. The Act insists that resource extraction must be done in an orderly and ecologically sustainable manner. It has to promote social and economic development, but justifiably so, not growth at any cost.
Right, sustainability first, and the other side, transformation, big time. Section 2 calls for promoting equitable access for all people of South Africa. It specifically targets expanding opportunities for historically disadvantaged persons, and that includes women and entire communities. It's about actively fixing the results of past discrimination.
And that term, historically disadvantaged person, it's formally defined in the Act, isn't it? Yes, it's defined clearly. Any person, group, or community disadvantaged by unfair discrimination before the Constitution came into effect. And this isn't just lip service. It connects directly to requiring broad-based economic empowerment, or BBE, as a core strategy for the industry. So transformation isn't an afterthought. It's baked into the core requirements.
Exactly.
Resource development has to serve that broader social purpose. Now, this raises a question. If the state is the ultimate custodian, why would private companies invest the huge sums needed for mining or drilling? Yeah, where's the security for them if they don't own the minerals in the old sense?
That's where Section 5 comes in. It's a clever legal solution. Once the state grants a prospecting, mining, exploration, or production right, and it's properly registered, the Act defines that right as a limited real right.
Okay, limited real right. What does that actually mean for, say, an international mining house? In practical terms, think of it like this. The state retains ultimate ownership, the custodianship. But the limited real right is like a very strong, secure lease or title deed specifically for the minerals and the land involved, lasting for the duration of the right. It provides genuine security of tenure.
Ah, I see. So the company can confidently bring in billions in equipment and capital because they have a legally protected right tied to the land itself, enforceable against others.
Precisely. It's not absolute ownership, but it's a secure, bankable interest. The state is the landlord, but you get a very solid long-term lease.
Okay, that makes sense. So how do you actually get one of these crucial rights? What's the process? Chapter 4 lays this out, right? Yes. Chapter 4 details the step-by-step regulatory path. It starts small, with reconnaissance permission. This is really just for doing initial surveys, maybe geological mapping or aerial surveys.
Very limited then. Very. It's valid for only 1 year, can't be transferred. Section 15 is clear. You cannot prospect our mine with this. Just basic reconnaissance. So if reconnaissance suggests there might be something valuable,
then you apply for prospecting, right under Section 17. And here, the requirements ramp up significantly. You need a solid work program, yes, but critically, you have to prove you have the financial resources and the technical ability to actually do the prospecting work.
And the environmental checks start here too.
Absolutely. You also have to show that your prospecting activities won't cause unacceptable pollution or ecological degradation. This right can be granted for up to 5 years initially.
And can it be renewed? Yes, once, for a period not exceeding 3 years, so potentially 8 years of prospecting in total. If that confirms a viable resource, then you aim for the main prize, the mining right. This is the big one. Section 23. How long can these last?
They can be granted for up to 30 years. And significantly, they are renewable for further periods, each also up to 30 years.
Wow, 30 years, renewable for another 30. That's potentially a very long time.
It is. And that long duration is considered necessary to justify the massive long-term investments involved in establishing a large mine. But getting it requires more scrutiny. The minister has to assess if the plan represents optimal mining of the resource. And crucially, you need a comprehensive social and labor plan approved up front.
That S&L plan again, we'll come back to that. Is there anything for smaller operations? 30 years seems geared towards huge projects.
Yes, there is. Section 27 provides for a mining permit. This is designed for much smaller, quicker operations. The key criteria are that the mineral can be mined optimally within 2 years, and the area involved is small, not exceeding 5.0 hectares.
So more for maybe local quarrying or a small alluvial diamond operation.
Exactly. It provides a pathway for smaller players.
Okay, across all these rights and permits, you mentioned environmental checks. How integrated is that? Is it just another form to fill out?
No, it's far more fundamental than that. It's
Yeah.
deeply woven into the process. When you apply for a prospecting right, or mining permit, you must simultaneously apply for an environmental authorization.
Simultaneously, not later.
Correct. It's not sequential, it's parallel. And that environmental authorization falls under the National Environmental Management Act, 1998 NEMA. Getting that NEMA authorization is actually a condition precedent, meaning it has to be granted before the MPRDA right or permit can be officially issued.
So no environmental green light, no mining right, period.
That's the rule. And Section 5A drives it home. It explicitly prohibits anyone from prospecting, mining, or even starting related activities without having both the necessary MPRDA right or permit and the NEMA environmental authorization in hand.
There's another requirement in 5A too, isn't there, about landowners?
Yes. You also have to give the landowner or lawful occupier at least 21 days written notice before you start any work on their property. Communication is key.
Okay. And what if a company holding one of these valuable rights wants to sell it or transfer it to another company? Is that straightforward?
Not automatically. Because these rights stem from the state as custodian, any transfer or cession needs the written consent of the minister, according to Section 11.
And the minister will just check the paperwork.
No, the minister has to be satisfied that the company receiving the right is capable of meeting all the original requirements. That includes having the necessary financial resources, the technical ability, and importantly, satisfying the BBEE and transformation criteria.
So the state maintains control over who ultimately holds these rights, ensuring the Act's objectives aren't diluted through transfers.
Precisely. It keeps the focus on capability and transformation throughout the life of the right.
Let's dig into those socioeconomic duties a bit more. We keep mentioning the social and labor plan, the S&L plan. What does that actually involve?
It's a detailed, legally binding plan required for mining rights and also for production rights in the petroleum context under Section 84. It outlines exactly how the mining company will contribute to local socioeconomic development. Think skills development, local procurement, infrastructure projects, and critically, how they'll implement broad-based economic empowerment within their own structure and through community engagement.
So it's the company's roadmap for delivering tangible benefits beyond just jobs and taxes.
Yes, and it's monitored. It's not just a plan that sits on a shelf. It forms part of the enforceable conditions of the mining right.
Does the Act also provide ways for communities themselves to benefit more directly, maybe even hold rights?
It does. Section 104 is quite interesting. It allows the minister to grant a preferent prospecting or mining right to a community, specifically for land that's registered in that community's name.
Preferent meaning they get first dibs, essentially.
Effectively, yes, provided the proposed project will genuinely contribute to the community's development and social upliftment. It's a mechanism designed to empower communities to leverage resources on their own land. Now, crucial question. Mines don't last forever. What happens when the digging stops? Who cleans up the mess? The Act is very clear on this under Section 43. The responsibility doesn't just disappear when the mining stops. The holder of the right remains responsible for any environmental liability, pollution, ecological degradation, and any damage caused by their activities.
Remains responsible until when?
Until the minister issues a closure certificate. And getting that certificate isn't easy. It requires confirmation not only from the Department of Mineral Resources and Energy, but also from the chief inspector responsible for mine health and safety and other relevant government departments. They all need to be satisfied that the closure plan has been executed properly and the site is safe and stable.
So the company's on the hook, potentially for years after closure, until the state formally signs off. That's significant long-term liability.
It has to be, given the potential long-term environmental impacts of mining.
What about overseeing all of this? Is there a specific body?
Yes, the Act establishes the Minerals and Petroleum Board. Its role, among other things, is to advise the minister on policy, sustainable development, and importantly, on the transformation of the industries.
And if companies don't comply with the act or their specific rights?
The minister has enforcement powers under Section 47, including the power to suspend or even cancel a right if the holder contravenes the act or breaches a material term or condition of their right.
There's also an interesting provision, Section 52, about financial trouble, isn't there?
Ah, yes, Section 52. This requires a mining right holder to formally notify the minister if their financial situation deteriorates significantly. Specifically, if their profit-to-revenue ratio drops below 6% on average over 12 continuous months.
6%. Why does the government need to know about a company's specific profit margin?
Because prolonged low profitability can signal potential mine closures or large-scale retrenchments, which have huge socioeconomic consequences. The holder must also notify the minister if they plan to curtail operations in a way that could affect 10% or more of the workforce, or more than 500 employees, whichever is less.
And what happens after that notification?
It triggers a process. The board is likely to investigate the situation and advise the minister on the potential socioeconomic impact, especially on jobs and community stability. It gives the state a chance to engage, perhaps explore alternatives before major disruptions occur. It underscores that mining isn't just a private business affair, it's tied to national and community well-being.
Okay, that makes sense. Now, let's talk about a major shift happening right now. The act we've been discussing, the MPRDA, covers both minerals and petroleum, right? Solid stuff and oil and gas.
Historically, yes. Chapter 4 deals with minerals, and Chapter 6 deals with petroleum exploration and production, which has its own designated agency managing it. But that's about to change, quote, fundamentally.
How so?
Well, there's an amendment that hasn't commenced yet, but it's sitting there in the legislation. It will actually change the short title of the act. It's set to become just the Mineral Resources Development Act, 2002. Yeah. Notice what's missing.
Petroleum is being taken out of the name.
Exactly. And the long title is also being amended to remove references to petroleum. This signals a major legislative split.
Why the split? What's driving this? It's directly linked to a whole new piece of legislation, the Upstream Petroleum Resources Development Act 23 of 2024. Once that act comes into force, let me guess, the petroleum parts of the MPRDA fall away.
Precisely. Chapter 6 of the MPRDA, covering petroleum exploration and production, is slated for repeal. So the MPRDA will soon focus exclusively on solid minerals, while oil and gas get their own dedicated legal framework.
That's a really important context for anyone dealing with this act right now, knowing that this split is coming. It certainly simplifies the focus of the MPRDA going forward.
It does. It separates two very different industries into their own regulatory regimes.
With all this complexity, state power, and ongoing change, what protects individuals or companies dealing with the administrators making these decisions? Is there a check on that power?
Yes, a crucial one. Section 6 of the Act explicitly states that any administrative action taken under the MPRDA must comply with the Promotion of Administrative Justice Act, commonly known as PIJ.
And PIJ requires?
It requires administrative action to be lawful, reasonable, and procedurally fair. Critically, it also means that decision-makers, like the minister or regional managers, have to provide written reasons for their decisions upon request.
So if your application is denied, you have a right to know exactly why in writing. That's fundamental for transparency and potential legal challenges.
Absolutely. It's the legal safety net ensuring decisions aren't arbitrary.
Okay, so looking back at our deep dive, the MPRDA is clearly doing a lot. It fundamentally shifted resource ownership to the state as custodian. It mandates social transformation BBE, the S&L plans. It tightly integrates environmental protections through NEMA as a non-negotiable first step. And, as we just discussed, it's in the process of a major overhaul to separate out petroleum regulation.
It's a complex balancing act, trying to manage national wealth for the benefit of all, while attracting investment, protecting the environment, and driving social change. We've talked about the state's power to intervene if a mine is struggling financially.
Under Section 52, yeah.
But the Act contains an even more fundamental power for the state to achieve its objectives.
Which is?
The power of expropriation. Section 55 gives the minister the authority to expropriate private property if it's deemed necessary for prospecting or mining. specifically to achieve the Act's core objectives like transformation or sustainable development. Of course, this must be done according to the Constitution's rules for expropriation, including just compensation.
Expropriation. That's the ultimate assertion of state power over resources, even against private land ownership. And it leaves us with a really powerful final thought for you, our listener, to mull over.
Indeed. How does a nation, through its laws like the MPRDA, truly strike the right balance? The balance between the undeniable need to develop its natural resources for national benefit, even using expropriation if deemed necessary, and the equally fundamental need to protect the rights of individuals, landowners, and communities.
That tension between national development and individual rights lies right at the heart of this act and the ongoing story of South Africa's resource wealth.